Hey, it's not a,
Hi,
there
Cari,
we
I
go.
forgot to record.
Okay, let me start
Perfect
over
timing.
because we're going to talk about information today. And if you ask questions, I want to make sure you understand we haven't engaged in an attorney-client relationship, so it won't be confidential if you ask questions. So just a heads up.
Perfect.
But anyway, let me get into an introduction on this. So this is actually my family. I'm minus the youngest, who's actually not in this picture, but I'm father of 8 kids. I've been practicing law for 20 years. Graduated from the University of Gonzaga in 2004. Um, Out of graduating from law school, I clerked for the Nevada Supreme Court. I held a position, one of 2 attorneys that clerked for a judge, call it justice in the Supreme Court, which was the highest court in the land. I know if you're watching the news, you're hearing a lot about different Supreme Courts and state Supreme Courts making different rulings. And so it's intriguing for me because I got to see the inner workings for a year on how that works and kind of the mind thought process of some of the best legal minds in our nation. So I'm currently licensed in 6 states. I own and operate my own law firm. We're licensed collectively in 23 states, and we have a network of attorneys in all 50 states. So we do a national practice where my background before going to law school was finance. I was the only business finance major in law school when I went there. So I've always been intrigued with planning and investing. I worked for Fidelity Investments out of graduating on my undergraduate degree for a couple of years before I went to law school. So I understand planning. So everything that we're going to talk about is going to be related to that. Our firm has set over 10,000 businesses. We do hundreds of estate plans every month, thousands a year. So everything we talk about, I haven't updated my slides. I'm actually a judge too in 4 cities in Utah. It says 3, but we added another one in the last year that we were also doing that. So, okay. So I bored you with who I am, and obviously I know your biggest thought after looking at this, slide is how did he end up with her? I still don't know. For sure, I hit the lottery double times over. There's no way she should be with somebody else outside of me, but that's just how I feel. So anyway, let's jump into this. I don't know how your holiday season was, but my season was dealt with a lot of emergencies. I had a guy that came to me in the first part of December, and his father was ran to the hospital, and the request was totally not expected. 65 years old, should live well past 65. My dad died a couple years ago at 84, and I thought, well done. If I can make that, then great. I don't think I'm going to, but if I do, great. But 65, you kind of expect in this time to live past 65, right? I was on a call earlier today with a client, and we were talking about Medicaid and the cost of long-term and short-term disability and health care. And he was like, hey, my dad's got dementia. And I said, well, how old? And he's like 60. And I was like, well, it reminds me of Bruce Willis, what he's going on with right now, but still way too young. My mom, who's 86, still alive, but she's got dementia. It's just a different things, like things come up. And so what I found though in talking to individuals is that most people don't plan for this. Like I would say a vast majority. It's not just my opinion on that, because I always talk to clients when they come through the door, like, hey, have you got anything in place for this? Have you protected yourself for this? And I would say 90% of the clients either have never done anything like this before or have, but they haven't looked at it in so long that it's so outdated, it's an ineffective plan. So what we're going to do is talk about today about what an effective planning looks like. All right. And I call it advanced planning. It's what's on the slide, but just understand this. It's planning. It's planning for the future. I just bought a book that I'm starting to listen to. Maybe you guys have listened to it. It's called The E-Myth. I don't know if you guys have listened to any of that, but so I just, as a business owner myself, I'm always kind of looking at what things I can do to improve. And first chapter, this guy talks about the reason most small businesses fail is they don't have systems and processes in place. It's not that they're not good workers or they're not hard and diligent out there drumming up new business. It's because they don't recognize what necessary systems and processes they need in order to be successful. And I think for all of you, you're out there, you're doing real estate, you're you're out there doing your realtor deals or whatever, engagement you're in business. You're out there and you're doing something. But are you doing it in a manner and method in which you're protecting the entirety of your estate? And we often think of like, oh, protection is like businesses and things like that. So we want to save for taxes or we get sued, but we forget that another huge portion of this is all the benefits that are available to you to have advanced planning to make sure that your home and your family are taken care of, right? So we're going to talk about what that looks like today, just for a few minutes, and then I'll answer some questions, and then I'll give you an opportunity to ask more questions later on. And that's something that we're going to make available for you as a free strategy session where you can meet and talk to somebody about this as well. Okay. So when we're talking about succession planning, what we're really is we're talking about handling two primary issues. One is, how do I transfer my assets? I've got this nice client from South Carolina, Mrs. May, I'll call her. And she's just the sweetest lady. And she's like, Mr. Greg, I don't have a lot of assets. I don't have these things called assets. I just have stuff. And I just laugh because she's a millionaire. She's got a lot of stuff. Like, she's got a lot of stuff, that stuff, that's a lot of stuff. So I'm like, okay, well, you still want to make sure, Miss May, that we take care of this and we send it where it needs to go. And so one part of what we do is we try to handle transferring of assets when we pass, okay? That's only one segment. We utilize two primary instruments to do that. Most of you have probably heard of the first. It's called the last will and testament, or a will, right? People are familiar, they understand the concept, but they don't really understand it. So we're going to go through what a will is in a second. The second thing they have is called a trust. Now, a trust is a wonderful instrument that I utilize for a lot of different clients for multiple reasons. And whether you're newlyweds out of college or you're a multimillionaire, I utilize a basic trust that I'm going to go over and explain why in a second. So for transferring assets, we do a will and a trust. There's more documents than that, but I'm only going to keep it. We only have an hour. I can't go through all the minutiae of everything else. But those are kind of the basics. Now, the other side of this is what happens in my life if something happens, but I'm still around, I'm still alive, but I can't communicate my desires. I don't have full capacity to handle my affairs. Are there instruments in place that can help for that? And there are. So the second part of this is what I call the medical directives. There are two primary medical directives we're going to talk about today. One is called the general power of attorney. That's if I can't communicate my desires either because I'm in a coma or I have dementia or I have Alzheimer's or Parkinson's or something that precludes me from telling somebody what I actually want to do. This allows me to designate an agent who can then pay my bills and make sure that I can live. Because if I don't have that in place, guess what happens? There can be fights and contention over that. And I can tell you, I've seen the worst of it. And you think that everybody gets along, we're all holding hands and singing Kumbaya until money becomes an issue. And then it's all over. It's all over. So we have a general power of attorney that sets out clear rules on how things are to be handled financially if I can't communicate in advance, not when it happens, but before it happens. The other document we have is called a healthcare directive. It's also like a healthcare power of attorney, right? It handles the medical decisions like getting access to prescription drugs and medical care and treatment and making sure that's in place. Because what if one family member's like, dad, mom really needs to go into long-term care, but the other members are like, no, didn't do that. Well, I can decide in advance what type of care and treatment I want. And if it's really beneficial for me, I can put that in and tell who I say and my family and my kids, I've got 8 of them, which one's going to say, okay, I have the definitive say. This is what we're doing because dad told me this is what we're going to do. So today, let's go into that. Now, collectively, these two issues, we call that an estate plan. So if you've heard of what an estate plan is, it's really a collection of documents that handle two primary issues. But it has to be done correctly and it has to be updated, otherwise it becomes non-effective. So let's go in and talk about this. So a good plan, a good succession plan doesn't just handle our assets of our home and everything, but handles how we're doing business. So because all of you are in some sort of business activity, you're in real estate, you're realtors, you're engaged in some sort of business. We're going to talk about how that ties together as well, okay? Because we can't overlook this really last thing, which is how do we handle these primary issues. So we're gonna talk about not having things in place because unfortunately it happens all of the time. Somebody dies unexpectedly. My neighbor that lives behind me, 56 years old, had a heart attack and died a couple of years ago. Left a family of four, all kids my kids' ages. He was older than I am. But I took this guy, we would go to dinner with him and his wife. We would go to basketball games. We would do things, and they knew what I did. And we talked about estate planning. It took me 6 months to help his surviving widow take care of the affairs of the estate after he died because he didn't have any of these issues in place. So we don't want that. We don't want that. So let's go ahead and talk about some of these things. Okay. What's a will and why do I want to have one? So I said, okay, listen, there are two primary documents we're going to do for an estate plan for asset transfer. The first is called a will. Now, most of you, if you've watched Knives Out or some movie like back in the day where everybody's around this big oak table and they're reading grandfather's will, they think, oh, you just go around a table, you read it, and then you're like, okay, you take the silverware and you take the car and I take the house or whatever. It doesn't work like that, okay? What happens is if you die even with a will, you have to go through a process called probate. And I'm going to show you what a probate looks like in a second. But with a will, it does do a couple of things. First and foremost, if you have minor kids like I do, then you want to make sure that you can name guardians for them in case something happens to you. So a will does that. It allows you to name guardians. So this is a tragic example I'm going to go through right now. This is the Openshaw family. So back in July of 2020 or 2015, you notice it says June. But the reason why I haven't updated this example is because this is something I have personal experience with. So in July of 2020 or 2015, I get a call and I meet with a family. They come in to do an estate plan. And I sit down with them across the table. And as I always do, they were in their early 40s. And I said, hey, why now? Why have you decided? Because I'll ask you, if you decide to use one of our services and you do an estate plan with us, I'll ask you, like, why now? What did you do? Like, was it watching the live cast? Was it this or that? Or why now? And so I asked him, well, why are you doing this now? And they said, well, we were really good friends with Mark and Amy Openshaw. And Mark sat on the Board of Education in the state of Utah, where I live. And I didn't know him personally, but he was going back and forth from Missouri to Utah, and he owned a small plane. And after takeoff, the plane had mechanical issues and crashed. And when it crashed, it killed him and his wife, Amy, and their two teenage kids that are shown in this picture. But who survived was their 5-year-old Max. He was in the back of the tail and he broke his arm. I believe miracles, miracle, right? This is a miracle. This kid walks away with a broken arm. But that leaves a dilemma now. His parents are gone, successful business person, successful politician, doing things right. Guess what he didn't have? No will. Nothing in place to make sure that Max was going to get taken care of. So the family that came to me, which I'm not going to divulge their names, they came to me and they said, we don't want this to happen to our kids. We have 5 kids of our own. And we want to make sure, because we're watching behind the scenes what's happened in the last month, is you've got grandparents A that have filed a petition for custody, grandparents B that have filed a petition for custody, and then cousin C that says, hey, I live in the neighborhood. He should come live with me. So now you got these loving family members that were kumbayaing and holding hands that are now against each other. Horrible situation. This kid just lost his parents. He's 5 years old. I have a 6-year-old. Just lost his parents. Like, he should be grieving over that instead of worrying about where he's going to live. So a will allows you to name guardians for your minor kids. So some of you may say, well, I don't have minor kids. But what if you have kids that have minor kids? If they don't have this taken care of, they're just as open to this as anybody else. Now, I have 4 of 8 are minors. I have 2 seniors in high school that just turned 18. So I'm down to 4. But that's more than most people have it in a family. So, like, I still look at that and say, hey, I need to have something in place. So I have a succession plan in place for my kids. It's a guardianship I do through my will. And it says, because they're at different ages, I allocate money so that They all get the same upbringing as my 23-year-old who's in college right now, right? They still get the access to money and resources for activities. And then after they've been raised, that gets allocated, what's left over gets allocated evenly so that the money's allocated to take care of them. I get to do that through a will. What a wonderful instrument, right? That's one thing that it does, okay? The other thing that it does is it allows us to name people to receive our assets called beneficiaries. So when I was clerking for the Nevada Supreme Court, um, you get to know a lot of people. So Nevada's kind of there's 2.5 million people in Nevada, right? It's a smaller state. You may live in New York or California where there's millions and millions of people. So you get to know people, right? And when I clerked for the court, I played basketball with the Secretary of State, right? I mean, I knew the Attorney General personally. You get to know people, right? You get to know the governor and everything else like that. It's kind of cool. It's in Carson City, which is smaller than Vegas, and so it's kind of cool. Well, I got to make a lot of good friends, and so when I left the court, I kept in contact with them. And so in 2012, I get a call from one of the attorneys there that are now working as what they call a staff attorney for the legislature. And he's like, and he's with the attorney general's office. He's like, you got to learn this case. He's like, look this up. So he tells me about this guy named Walter Shemenko. So Walter lives in Carson City, Nevada, and his neighbors notice after a couple of days that Walter hasn't really showed up. So they call the police, they go over to the house, and they open the house up, and they find that he's died of a heart attack. Terrible. Walter lives by himself. They don't know any family members, but they're going through and they open his garage, and what do they find? $6 million worth of gold bars and rare coins in his garage. So my buddy's calling me and telling me about this because he's like, hey, guy doesn't have a will. There's no beneficiaries. There's nobody listed to receive his assets. State's going to have a huge windfall on this. So now the moral of the story is this is what happened. This is what we all want to happen. Like some uncle or cousin we didn't remember leaves us a ton of money. And we're like, whoo, yay, we got this. Well, that's what happened to his cousin. So his cousin actually attended his mom's funeral, Walter's mom's funeral 20 years before, and signed a registry that she had attended the funeral. Well, this part-time substitute teacher living in the Bay Area, California, gets the call of her life from the state of Nevada saying, hey, you're the closest relative that we can find. And not only did Walter have $6 million of gold bars, but he had retirement accounts, he had this house, and it collected the state over $7 million. We're going to take our share for taxes, but you're going to get the lion's share. Merry Christmas, happy holidays, whatever you want to celebrate. Here you go. And she inherited it all because he didn't have a will in place. Okay. And I wish this was an uncommon occurrence, but it happens all the time. So will is a wonderful instrument to do that, but it has limitations. So if we want to avoid going through this process called probate, and I normally ask this if I'm in person, I'm like, have you gone through probate or do you know somebody's gone through probate? And I have yet in 20 years had somebody raise their hand and said, I went through probate and that was the most wonderful experience I ever enjoyed. I was like, no, it's a horrible experience. Because if you go through probate, and there's a client that came to me over the break, it's my niece's husband's parents. And I know that sounds like Ferris Bueller's, right? We go every year. I rent out a movie theater and we watch a movie. And so they were in town, and I said, "Oh, come with us. We'll go. It's really fun." And so we went to see this movie, and after the movie, they're like, we know you do estate planning, Greg," which normally opens a conversation where I'm like, "Okay, all right, I'm ready." It's like the 23rd of December, and I'm gonna be talking business for the next hour, but that's okay. I like helping people. And they're like, "Hey, so my dad died in August of the last year, and we're trying to get this reconciled, and we're going to have to go through probate. And my brother, who's the administrator of the will, won't give me any information." So I sat down, I looked at this, and I actually dealt with correspondence on Christmas Day. That's what I get for being a nice guy. On Christmas Day, I'm sending emails about back and forth about this contention. We're talking about an estate that's worth about $300,000. But I'm telling you, the way that this family was going, it was like this estate was like $20 million. This thing is headed for one of the worst probates for, I mean, $300,000. I'm not saying that's something to laugh about. Like just disregard. It's sufficient, right? It's not $10,000, right? But still, it wouldn't be something you would think that people are going to go to battle. This is going to be cage match, But it is. This thing is going to go into court. They have a will, but It's going to go into probate. So probate's the process to wind down the affairs of somebody who's died, even with a will. And it's not a fun process. In most states, probate's going to cost you $20,000. So with this, I mean, they're already into attorney fees. I didn't charge them, but I know I told them right off the bat. I said, you're gonna have to go to a probate attorney that goes into court all the time. I try to help people avoid probate, and I do probate stuff, but not frequent, because my clients do it right. So you're gonna have to probate this case, and it's gonna cost you $10,000 to $20,000 easy on this. It's a process that's 100% unavoidable. Why? Because I can use an instrument called a trust that allows me to avoid. So when you die with a trust, you can go in and you can administer the affairs of the state by having two things: a trust certificate, which just shows proof of the trust, and a death certificate. And if you have those two things, you don't have to use a court. You don't have to use attorneys. You can do what you think the movies do, where you're sitting around the table and you're like, well, Bill, why don't you take the car? That's what Dad said here. Or, hey, Jane, and here Mom says you can have her wedding rings. And then you distribute it just like that. It gets taken care of. Now, there's a little more to it than that. And you know what we did when my dad died? I actually had to administer his estate, even though they had a trust, because I had to figure out. My mom has dementia. So I had to figure it out. And it took me several months to do it. And I said, you know what? There is no way a layperson is going to figure this out. I'm an attorney, and it took me 3 months to kind of put this thing together. So do you know what I created for people? For my clients, I created a document called Successor Trustee Instructions for Dummies, because I'm the dummy. I wanted to figure out in easy steps, like how do you administer a trust? So we help that too. So you don't need to come back to an attorney. I tell you, step 1 is this, step 2 is this, all the way through step 10. And if you follow these steps, you're going to be able to administer your trust without any problems. So trusts are wonderful instruments. They allow us to do flexibility on a whole bunch of things we don't have time to talk about today. We just got back from Yellowstone. We have a cabin up there. And this last year, we finished a garage with a 2-bedroom apartment, which I'm going to Airbnb, that I just created a new business for. So it's going into that business, and we're going to list it for, I'm getting a photographer taking pictures tomorrow, and I'm going to have it listed for 2024 for rent. So I'm hopeful that I can live the dream like all of you probably do right now, and having an Airbnb or a VBRO. Okay. So in this year, but in my trust, I've changed. I modified my trust in November. I said, hey, listen, kids, I'm going to leave this cabin up in Idaho that's by Yellowstone. I'm going to leave it to you guys to use for personal use. And here are the rules. But I've also got this business I set up for this rental that I've got. You cannot sell this business. You cannot sell the assets, but you have to manage and run this business and take the income from this business and pay the taxes on the cabin and the upkeep for new carpet and maintenance and wear and tear for both properties. And that's in my trust. And you know what I can do? I can put that in my trust. You know where I can't put it? In a will. And if I don't have clear dictation of how this works, how are they going to know how to run this? Trusts are wonderful instruments. You can create a legacy for things that you can't do through a will. So I love trusts. And I wish I had more time to talk about trust today, but I'm limited to the amount of time. And I want to allow some time for question and answers today as well. So this is how probate works and why I hate it so much. So a typical probate goes like this. Somebody dies. Family's like, what do? We don't know what to do because we're not attorneys. Well, let's call an attorney. So they call an attorney up and they're like, I know what to do. I'm a probate attorney. We need to file a probate petition. So they go and they fill out the paperwork. It takes them probably 10 days to do that. And they file a petition with the court. Now it's been about 30 days since mom or dad has died. So we're already 30 days in the process. What does the court do? The court says, hey, listen, I need to have a list of creditors, people that are owed money from the estate. We need to know who those people are. So probate attorney, file a list of creditors. So the attorney's like, okay, I got 30 days to do that. They collect all the information. So we've already waited 30 days to file the petition. Now we've waited 30 days to give a list of creditors. And then the court says, hey, we're going to give those creditors 90 days, 3 months, to raise their hand and say, I want to be paid out of the estate. And if they don't do it in 3 months, they waive their claim. But if they do it in 3 months, they can come in and they get to get paid from the estate. Even though the person that they owed them money is now gone, they get to have a claim on the estate. So now we wait for 3 months. So now it's been 1 month, 2 months, 3 months, 5 months. And now we've got a list of creditors that say, I'm the ones I want to get paid. And the court says, Okay, negotiate a settlement, pay it. And that becomes open-ended. And you sit on that as long as it takes to get those creditors paid off. Okay. So, and that's in an uncontested case. Now imagine the case I just mentioned to the family over Christmas. They're going to be fighting court over that for years because they're not going to agree on terms. And so what happens is you spend a lot of time and effort and money over something you can totally avoid by having this trust in place. So it's just a waste of time. Now, if you're fortunate enough to be one of my California IA clients, which I have a lot of, and I love California, my family's from the Central Coast. If you stop by San Lo and you go to Firestone, get me a tri-tip sandwich because I'll love you forever for it. Just whiff it and yeah, it's great. But I'm just saying, like, I love California, but living there, if you die with a will in California, you're going to pay bank for having to probate that estate. My aunt who lives in Santa Maria, California, she worked as a clerk for years, for 30 years as a clerk for one of the judges there. And they would do all sorts of cases. She was actually, her judge did the Michael Jackson case, if you know what that is. Anyway, in California, if you die without a trust, you have to go through this probate process, and the state takes money from your pocket. For the first $100,000, they're going to take 4% or $4,000. For the second 100,000, they're going to take 3%. For the third 100,000, they're going to take 2%. So if you have the average size home in California, which right now with inflation and everything else is about $774,000, you're going to pay $18,000 in probate fees. What does that not include? Your cost for your attorney, the cost for the courts, the cost for renovation, appraisals, anything else. That's just for you dying in the state of California for that one asset. Now, if you have other assets, guess what? That adds on to that value. So if you have a trust, no cost. No cost. You don't have to pay that because you don't have to probate it. So you avoid it altogether. And California is not alone. Texas has it. Florida has it. So you can see Florida, it's 3%, 3% of the value. So if you've got $1 million estate in Florida, $33,000, it could be that. I had a client that came to me. I did their trust a few years ago, and their dad died and had a trust in Florida, but didn't transfer the assets into the trust. So he died with those the real property, 16 rental properties in Florida. They paid $30,000 in probate fees, and he had a trust. So one of the things that we do is that we don't just help create a trust. We do three things. What we do with estate planning, we haven't got into medical directives yet, is three things. One, we educate, because clients that understand how these documents work use them better than the clients that don't. So we train a lot. It's like this. We spend a lot of time clients going through the information I'm going through with you right now. Number two, we listen. We listen to what your situation is, because believe it or not, I've never drafted the same estate plan twice, because different people have different needs. You maybe I've got this nice doctor out of the South. He's in Virginia, and he's been married 5 times. His needs on his estate plan were way different than the average person. And there's no shame for 5 divorces. I'm just saying that there were 5 different marriages there that we had to deal with, okay? And we took care of it because we have to listen to what your concerns are, because your concerns could be different. Listen, my oldest son's autistic, so I have different concerns than most people because I don't know what life's going to be for him. He's 21 years old. He starts college next month, and it's going to be like, we're still going to see how life's going to be for him. So I have specific provisions as a backstop to protect for him. Your needs are going to be different, and we're going to listen to those. The third thing we're going to do, you don't know what you don't know. If you've never done this, or even if you've done it and the attorney didn't educate you like I tried to, you may not know what to do. You may not know what provisions to put in, so we consult. I had a client a couple weeks ago. It's like, hey, we're doing a trust. We're taking care of this. I really don't want my children as beneficiaries to be in debt when I die. So if they're in debt when I die, they get nothing. And I was like, holy cow, that's crazy. Your kid's 14 and 16. What if your 16-year-old decides that she wants to go and enter the most noblest profession that I can think of, which is public education? And they decide that they're going to be a public school teacher, teaching elementary school. Well done for them. But they get out of school and they've got $50,000 in student debts, and they're making poo for money because we don't pay our public educators enough, right? Both my grandparents were public educators, so if you can't tell I'm on a soapbox, I'm a little bit of a soapbox. Anyway, so I'm like, okay, what about that? She's in debt because she became a school teacher. You're not going to leave her anything out of your estate. And he's like, no, no, that's not what I mean. I just want them to be financially responsible. I'm like, okay, well, let's build that in, right? Let's build in financial responsibility, but not cut their head off if they become a public educator. So we did. I gave him 5 different options to do it. He's like, I love option number 4, and that's what we went with in his trust. That's what we do. We consult with you because I've been doing this for 20 years, and it's very rare that I hear a question that I have an example of some other estate plan that we've done for somebody else. So we do those things. So when you're thinking about a trust, we do that. Now, there's a whole bunch of different roles with trusts, and people don't understand how it works. The main role in a trust is called a trustee. You can forget some of the other roles. It's like being a manager of the business, okay? It's the manager. In your lifetime, you're the initial trustee. You're the master and commander of your own universe. You can do whatever you want with the trust. But when you die, you need to have what's called a successor trustee, somebody to step into your shoes to not make changes. They don't get to. Once you die, your plan is irrevocable, cannot be changed. It becomes an asset protection tool for your beneficiaries and cannot be changed, but needs to be managed. Hey, this goes here, this goes there. It's you're the quarterback. You're delivering the ball based upon what the coach is calling the plays. You're the coach. The successor trustee is a quarterback. If you understand the sports analogy, it's not used that as all. Then you have, sometimes if you're married, you have a deceased spouse or a surviving spouse. The deceased spouse is the person who dies first. The survivor is the person who lives the longest. No totems given out on this. It's just I have to define roles, and those are the terms I use. And then we do things. We give assets. We do it through a specific distribution, which is like my son Timmy gets Lassie. My daughter Dorothy gets the ruby slippers. Okay. So we get to say those specific assets go where, or we may say, I don't care. Let's just put it in a big pile and distribute that. We call that a general distribution. And then we say, well, are we giving it to them evenly? What if I have 4 kids and one of them dies? Do I give it to the other 3? Or what if that 4th kid that dies has 2 kids? Do I give it to those kids? So we decide that. So one is called per capita, where we divide it among the 3 remaining, or the other one's called per stirpes, where we give it, if the deceased child has 2 kids, so 2 grandkids, we give it to them. These are all things we talk about. I'm just going through really quickly so you can understand. So there's a lot to look at. Now, how does a trust work? It creates a bucket when it's set up. So a trust is an empty bucket when you're done. When you sign it, it's like, oh, I just opened a bank account without putting any money in it. Okay, well, what do we do? Well, trust to be effective, you have to do a couple of things. One, we have to put assets into it. So we fill that bucket with your property. We make sure it gets in there so we can transfer it. How do you do that? Well, guess what? We help you do that. Most law firms don't do that, just so you know, but we help clients do that. Because if you don't put the assets into the trust, it's like that client who came to me out of Florida. Her father's estate planner didn't help him transfer assets. We would have never done that. We would have made sure, like we did for her, that all of her businesses were taken care of, all of her real property was taken care of, all of her assets were taken care of. So we do that for you. Another thing you need to make sure is you update your trust. If you last did a trust in 1982 when Ronald Reagan was president of the United States, you're in trouble. You better dang well have updated that trust since then. I tell clients that trusts are kind of like furnaces and air conditioning units. If you have your furnace or air conditioning looked at once a year, that's pretty good. You don't have to read it every night. It doesn't need to be next to your bed. You don't have to read it like scripture. It's something there that you check on every once in a while to make sure that it's up to date. So once a year, what we do proactively is we send out a list to our clients saying, hey, have any of these things changed? If so, schedule an appointment. Because one thing that we do that's different from other law firms is we have an option to do an unlimited update trust, which anytime you have changes, you can reach out to us and we'll update, no charge. Why? Because I found over my career, if clients think that you're going to charge them, they don't call you. And so if we just build it into the initial purchase price and they know they can contact us at any time, then they're more apt to do it. Because trust should be evaluated on an annual basis, and we'll proactively reach out yearly. But for you, you can reach out to us at any time and we can take care of that. So whether you use our service or somebody else's service, that's something you need to make sure that you have for sure. Okay, different type of properties you have. You may have personal property. You may have accounts with listed beneficiaries. You may have real property. You may have businesses. There are different ways, depending on the property types, to transfer those assets into a trust to use it. We know how to do this. There's more assets than just these. These are the most common that most people have. And we know this night and day. I have 4 staff attorneys that help me with this. I have 10 paralegals. We have a network of dozens of other attorneys that we work with. So there's enough capacity that we work with people across the board on this stuff. Okay. Talked about asset transfer. We spend a lot of time on that. I'm going to briefly go through the medical. I don't want to minimize its importance, just so you know. This is super important. Let me go through these two, and then I want to open it to question and answer because I want to field some questions on this. Conservatorship is that general power of attorney. I need somebody to care for me. Before my brother at 61 passed away a couple years ago, and I'm the youngest. He was the second oldest, so 15 years gap between us. He was 61 at the time, and so we were really good friends. In fact, if you see my bookshelf behind me, everything on my bookshelf is something that's super personal to me. It's not just stuff, right? I don't like stuff. Behind me is his baseball mitt because he taught me how to play baseball. And that's my favorite sport. I know that's national pastime. It's like, is it? I don't love to watch baseball, but I love to play it. And so when he died, his wife said, "What do you want?" I wanted his baseball glove because that was the one thing. Everything else, I don't want anything else. I just wanted his mitt. So the reason I mention this is that he had a heart transplant before COVID hit. And then COVID hit, and he got stuck in the hospital for 4 months. Do you know what he couldn't do? Go out and cover his finances. So he had a general power of attorney that was in place because we did an estate plan. A couple years ago on Christmas, I gave all my family estate plans for my gift. And I sat down and I did plans. I made them do this. It took me a year to get them all to do it, by the way, and it was free. And I had to harass them to do it. We got it done, and I'm glad we did, because when he went into the hospital for his heart transplant, I had the general power of attorney. And so we were able to do financial decisions without going into court and having a conservatorship appointed over him. And so I was able to do that because he was legit in the hospital for 4 months because you couldn't leave. He had a heart transplant. If it was normal times, he would have been out within a 6-week period of time, but he couldn't. So it just happened to be we had the right documents in place. Now it came into a second time. He died in June of 2021. He died. In September, I get a call from my sister-in-law, and she's like, "Hey, I can't collect on your brother's life insurance policy. They won't pay out, and I don't know what to do. And I've been paying the premiums because I don't want it to lapse." Well, I lost my ever-loving mind. First off, she should have called me like 2 weeks into it, not 3 or 4 months into it. But okay, I had this conservatorship because I was his agent under this general power of attorney. Even though he was gone, I called that insurance company. I may have dropped a few words that I can't use in this this live stream today. But I told them in very short terms, if they didn't release this, I was going to sue all of them. And I didn't care. I was a man on a mission. I was going to take them all out. And I was going to go on every public network and tell them how terrible they were. Ironically, 2 weeks later, I got a check for the full amount that they owe. I don't know why it took 4 or 5 months with my sister-in-law, but within 2 weeks, I had a full payout. But the reason I was able to do it is because I had this document. You wouldn't even have guessed, but I had this conservatorship. I had something in place in advance that it was taken care of. Okay, that's one. The second is the healthcare directive. And I'm going to share one quick story on this, and then we'll go on from there. A healthcare directive allows you to make medical decisions for somebody else. Well, you don't get to make the decisions. You, while you have capacity, get to make the decisions and name an agent that enforces those decisions. Here's my one quick story, okay? So in the spring, I come home from work, and I'm a workaholic, but this time I actually get home at a decent time, which is 6 o'clock, which is probably not early for a lot of you, but for me, it was early. I walk in the door, and where do I find my wife? She is in the fetal position on our bathroom tile in our bathroom. And I'm like, "What's going on here?" She's like, "Oh, she gets bad indigestion. She just thought she had stomach cramps." So I'm like, "Okay, well, did you take the normal like Pepcid or Tums or whatever?" And she's like, "Yeah, I took it." Okay, well, let me go to the grocery store and get you an over-counter solution. I'll come back. So I come back, give her the over-counter. 3 minutes later, it has not improved the situation one bit. And I'm like, "Okay, I'm done with this. So let's call the teledoctor and try to figure out what's going on before I do anything else." So we get the teledoctor on the phone. Teledoctor's like, "You need to put your wife in the car and drive straight to the hospital." Now, she thinks it's an appendicitis. I don't know. I'm no doctor. I'm a legal doctor of law, juris doctor, but not a medical doctor. I don't play it at home. So I get my wife in the car and we drive to the emergency room. We get in there, and she's in so much pain. Like this kid has bared some kids. I've seen some pain. She is in pain, like I've never seen. And I'm like, "All right, bring on the stuff." And so they give her morphine, which I didn't know they gave anymore I didn't know like morphine was a go-to drug in the emergency room because I've heard that's an opioid or whatever and it's addictive, but okay. And so they give it to her and it doesn't do anything. And so 5 minutes later, I'm like, what's going on? She's still unpaid. And they're like, well, let's give her more. And I'm like, give her more? I've seen Saving Private Ryan. They put the M on because you're not supposed to give them more. Like, what are you going to do? Overdose my wife? And so they do. They give her more and doesn't do anything. Third time they come in there like, well, let's give her the real drugs. And I'm like, there's something more powerful than morphine. So they give her that. And then now she's seeing green monkeys. Like she is as happy. She is high as a kite. She is just like, I love you, which I wish she was always like, because, that would be awesome, but she's not. And then here's the kicker. The doctor comes in and says, hey, you've got a hernia. We got to fix this now or it's going to cause some problems. It could even kill you. So, but before we do that, you need to sign this medical directive so that we know that we've got systems in place if you are incapacitated for a while. And I'm like, are you kidding me? She's higher than a kite. There is no way she has capacity. She's been under pain for the last 4 hours because it takes terrible long time to get through the emergency room to actually get to the solution of the matter. And I'm like, there's no way she signed this. First off, husband attorney, we already have it in place. Second off, if you're doing this for other people and you're having them sign this, don't do that. They don't have capacity. Instead of being under duress like my wife was, make sure that you're in a place where you thought things out in advance. And that's what this document does. There's no way being high as a kite or in so much pain that you could figure out how to fill this out. Instead, have a competent law firm help you do that before you're in that place and take care of it. So one of the calls I had today was a sad one because this guy calls me. I mentioned it, 6-year-old dad's got dementia, doesn't have anything in place. And it's like, can you go now and get this in place? Way too young to be suffering for that. But that's why you have these documents in place in advance because you never know what's going to happen. So been through a lot of stuff today. Let me go through what the process looks like when you do this, because it sounds intimidating and overwhelming, and it's not. As I tell my kids all the time, how do you eat an elephant? One bite at a time. So we have a very methodical system. My dad was an engineer, so I do everything really like methodical. I'm analytical in my mind too, even though I'm an attorney. So we do a blueprint. It's a worksheet that's online. We walk through that. We have a video, shows you how to fill it out. We have a welcome call where you get on with me and you get asked a whole bunch of questions. We help you fill out the worksheet, and then you meet with our staff, and then we start listening and advising and counseling and drafting a plan. And then you get access to review that plan with one of our attorneys, and then we send it to you for signature. And then when you sign it, then we help you transfer your assets into that bucket. So you make sure that you're not that client out of Florida that died without having the assets put in the trust, or Michael Jackson, who died in California with millions of dollars of attorneys without transferring assets in the trust. So you fund it. And then when you need those modifications, we're there to help make those adjustments. You have another kid or your dad dies like my dad did, and I had to modify who my trustees were. We take care of that for you. So Sue Orsman, or I can't talk, Orman, she says this all the time. Estate planning is the most important gift. Last year, I had a client come back to me and bought 4 estate plans for his daughters. It was one of the funnest things. We got a big Zoom call. We're all doing this. We're talking it. Now, obviously, we got into details. It was one-on-one, but it was like a family reunion every week. We're talking about these estate plans. It was the best gift. His family, it was wonderful, right? And so a lot of my clients are referral clients. They'll come back to me because they'll be like, hey, I need this for my kids or whatever. Or for your clients. If you're dealing with clients that are coming to you for professional advice and they're investing in real estate or looking to buy or sell real estate and you're helping them with that, they may need this too. So that's something that you need to have in place. So it's time for question and answers, but just know this. For everybody, I've only estate planning can take me a long time to explain. And I'm trying to go through this really fast. I'm like touching the fringes. For those of you that need some more detail, here's a QR code. You can schedule a business strategy consultation with one of our staff that can go into more detail on all of these questions with you. It's no charge. You can do it at any time you're lenient. There's a lot of appointments. You do the QR code, you're going to see there's a lot of availability at different times and dates and everything else. So today we're going to be able to handle this much questions, and I'm going to go through and I'll get off my soapbox in a second. But just know this is available for you. It's a no charge no better time to make a better time to plan than the 3rd of January when everybody's making resolutions. We'll make a resolution to get this in place if you don't have this, or if you haven't had anybody look at it in a long time and you're not sure it's good, have us look at it. I do that a lot. I probably 40% of my business comes from clients that have had trusts or wills before, not maybe both or all of them, but one or the other. And they're like, is this good? And I'll be like, no, it's not. Well, if it's good, I'll tell you. If like you just had it updated 6 months ago and you come to me, I'll be like, you're great. But sometimes if you're not good, you don't want somebody to lie to you. So I'm not looking to make money when I, don't need to make money, which is, driving traffic or business when you're fine. I'll tell you you're fine. But if you're not fine, I'm also going to tell you that, hey, here are some issues. Schedule its free consultation to your own, it's part of what Cari's put together for you to be able to have access to education. That's all we're doing. So what I'd like to do over the next little bit is answer questions. So I'm going to turn it over to whoever's chatted questions to Cari. She can feed them to me, or if you want to raise your hand, there's that little icon. It's a smiling face with a plus sign where you can raise your hand. You could unmute yourself and we can answer questions.
Yes, thank you for the QR code. I also put a link if you wanted to copy and paste the link in the chat box and set up a call later too. I met multiple people, including Greg from Prime a while back, like I said, and they just shared all of the people that they've been helping with different various things. And all of a sudden I realized I knew a lot of those people, and the testimonials were really, really positive. And so I partnered with them to say, look, if once every couple of months you guys can come in and talk to business owners about what they need to do to protect themselves and their families, to keep more of their own money and tax strategies and do all of the things that mean, this means the difference to you treating this like a true business and being able to have in the future what you're building now. I'm just really passionate about that because Greg shared a lot of stories, and I personally have known many people who have fallen into hardships and wish they would have been more prepared as entrepreneurs. And so I do have a big heart for this. So you guys just unmute yourself. It's a small group here. I'm going to go look and make sure that we don't have any questions in the live stream. We've had a ton of people watching live stream, Greg. So lots of viewership. But while I'm doing that, does anybody have any questions or comments? Jen Bonner says, if you set up the trust while kids were minors, but now they're adults, do you need to change the trust? The assets and distribution haven't changed. Good question.
Well, but your philosophy could change, right? For your kids who are now adults from when they're minors, right? I know for mine, I allocate a certain amount of my trust proceeds to go to for their upbringing. I don't need to do that anymore. Maybe I've got a kid who's struggling with substance abuse as an adult that wasn't as a minor kid. So I need to go ahead and make some modifications. So the way I look at it is I always look and say, like, my 21-year-old is way different when he was 5. And so I've got to adjust to what they're dealing with. And your family and your beneficiaries better than I do. And maybe you're like, oh, we're fine. And maybe you are. I don't know. But in most cases, there's something that I can add into it that changes the dynamics of what you're doing, right? Like my son who's autistic, he's 21, graduated with honors from high school. He served a 2-year sabbatical for our church. He just got home. He's going to college. I don't know what life's going to bring for him, but it looks great. But I don't know yet. So right now, I have his funds held in a special needs trust. So if I and my wife die, my oldest daughter, who's 23, she kind of governs that for him so that it doesn't affect any potential benefits that he may need to get from the government to pursue his education or anything else. So what we do is we just assess the situation. We assess where you're at. And being adults, they're going to have different needs. Maybe they have a child and maybe they've got married. And so, okay, well, they're married now and they have kids. And well, what if I leave the money straight to them? Well, it's then their discretion whether they join that with their spouse or not. But maybe you don't want that. Maybe you want that to always stay in their name. So you want to put a provision in there that you didn't have before because now they're married and you want to make sure that your in-laws don't get anything. And that there's nothing wrong with that. I mean, you're not a bad, father or in-law or mother-in-law to a son-in-law that isn't your daughter. Mm-hmm. It's just life. You inherit from your parents, not from your in-laws. So we can do so much more. And I'm always looking at stuff like that. Things that you haven't probably even thought about because your kids were little, that now different dynamics. So I'm always looking at those things.
Yeah. So it wouldn't be a bad idea, Jen, if you have one already. It sounds like that, that's part of the free service. Let's look at this and see if there could be some
Yeah.
adjustments, things that we haven't even thought of before. That actually is a great question, Greg. It came up with somebody that I was talking with recently. When you have someone who could possibly be receiving something from the government in the way of disability or something like that, and they do get gifted money from a family member, how does that affect that? Or is there a way that that can be protected and not count against them? And that's a general question, or is that really case by case?
No, it is a general question, but it can be case by case, but it generally is, there's no
Okay.
rule, right? So like, let's use my son, I've already mentioned. So I don't know what accommodations or, assistance he's gonna use. Right now in life, he gets accommodations in the school, but not any government assistance. But I don't know in life what he's gonna need. For my clients who have that, like they have a son who's in, Down syndrome or something where they're getting government aid. I'll use my brother. This is a good example. I have a brother, I'm the youngest. My oldest brother's still alive. He's 67, way older than I am. I'm still in my 40s. And yeah, I know, right? So he's older than most, but it's younger than my brothers. So anyway, he's schizophrenic and he's on every type of, he's on Medicaid, Medicare, he's got unemployment and Social Security and all. If my mom were to die tomorrow and leave him $10,000, just $10,000, he would lose his benefits for 2 years. He wouldn't get food stamps, he wouldn't get any of that. I guarantee the assistance he's getting, because I know what it is much greater than $10,000 for 2 years. So how do I avoid that? Well, we did what I did for my son. We created a special needs trust in my parents' estate. His portion of that gets put into that trust. It never goes out of the trust. So it doesn't ever go into his name. I'm the successor trustee. So I get to use those proceeds in a way that won't affect his ability to get those benefits that he's getting from the government. It's 100% legal. It's 100% allowable. It's just something that we can put into place that the government is okay with. So we're playing by the rules, right? If I didn't have that in place and he got it, he loses benefits. But because I put it and I know what I'm doing, he's going to have that. Now, can I go and just pay for his rent or stuff like that? Maybe not directly because he gets other benefits that are attached to that. But you know what? He loves the Pittsburgh Steelers. And if I take him to go to Pittsburgh, Pennsylvania to see the Steelers play, and I pay for it and I get reimbursed from the trust, guess what he has to recognize? Nothing. Or he needs new code or clothes and stuff that doesn't affect that. So I can use the money for his benefit and he still gets that, but he doesn't have the detriment of losing his benefits at the same time.
Yeah. And so, that's great. There's probably more questions about that. Is there a dollar amount? I mean, that $10,000 isn't very much. Is there a dollar amount where it pretty much doesn't affect? Is there something like that, or does it just depend?
It's a low threshold when
Okay.
you get money. It's just like if you, and most people who know are on disability or in other things, they know what that threshold is. I get this all the time, even when I set up businesses. So like, hey, I'm starting this new real estate business, or I'm going to be a realtor, but I'm on Social Security or disability, and I don't want to lose that money. They know there's the threshold, and it's not much. It's a couple thousand dollars. As soon as you get that, it's
Yeah.
like the government. It affects. It's a
Yeah.
big swing in what you get.
Yeah.
So why even mess with it? Let's just
That's
go ahead
right.
and do this in the
Just
first
do that
place.
instead.
It's
Yeah.
easy and it's allowable. It's legal. We're just doing things that are legal. It's the same thing as maybe you got a kid that's in huge debt, right? And they've got all these creditors in there, but you want to leave them money. Well, we can leave it in the trust. We don't have to give it to them, and we can pay for things on their benefit. Guess who can't touch that? Their creditors. It's protected. It's protected. Is same thing too, is you put your assets in a trust and your kid goes and says, hey, I'm going to inherit someday $100,000 from this trust. Let me use this as collateral for that. Guess what? Null and void. Can't do it. So there's so many protections with a trust, and it's so flexible. It's just a wonderful instrument. It really is.
Yeah, that's awesome. Thank you for that. Jen has one other question here, and anybody else just chat in the chat box. Jen said that she was told her dad doesn't need a will because he doesn't own any property other than a 22-year-old truck and some personal items, just has 2 bank accounts. Is it sufficient to add herself to his truck title into the 2 bank accounts in preparation for his passing?
It depends. Some states have what's called a small state exemption, which will cover that. If the truck's worth under $10,000 and he doesn't have more than $10,000 in the bank accounts, it may or may not. It depends on the state where he's located in. Um, Even with a will, you'd have to go through probate with him, depending on the state. So one, we want to look at the state where he's at. Okay. Because if he falls under a small estate exemption, then I'd say you're probably okay on the asset transfer side. Your biggest exposure isn't going to be that. It's going to be the medical side. If he gets dementia or Alzheimer's or something, and you're trying to care for him and you need to get prescription drugs or care for treatment because there's HIPAA and a whole bunch of other things, good luck. You're going to have to go into court and get appointed a conservatorship over him to be able to make those decisions. Otherwise, the medical process, there's so much liability now that I have cousins that are doctors and they're like, we won't touch that unless they've got that in place because they don't want to get sued. And
Mhm.
so your biggest issue, if he has a small estate, and that's what we talked about, is not going to be the volume of the estate. He's still, depending where he's at, he still may need a will or trust. I'm not saying he shouldn't. You
Right.
want to look at that first.
Yep.
He may not, but you look at that. But say he doesn't, then I'd want to worry about getting the medical directives in place, making sure you have a general power of attorney and a healthcare directive.
Yep.
Um,
Yep. Irrevocable trust, is that ever needed or should it always be revocable?
My
Julia.
baseline foundation for everybody is a revocable living trust, multi-millionaires to newlyweds. Then we do an assessment, right? We talk to the client, see where they're at, what assets they have. Some assets have more risk to exposure than others, right? If you have a 401k or IRA, already have great asset protection. We don't need to utilize the trust for that. And you get control of that and you have full control of using it. So we don't touch that. If you live in a state like Texas or Florida or Kansas that have unlimited homestead exemptions, you don't really need an irrevocable trust to protect that asset, right? It's already there because the government says it's protected by state law. Or if you have certain vehicles that people, I mean, like you have a minivan, I'm not putting that in irrevocable trust because nobody's going to sue me for my minivan, so to speak. I call that, non-risky assets, right? So what we do is, first thing we do is we find out what asset types. You don't have to give us a list of broken down of what assets you have. We look at the asset types and then we assess whether there's a need for an asset protection trust, which is an irrevocable trust. Now, why do I take my time before I do that and do an assessment? Is because an irrevocable trust does offer some asset protection in certain cases. There are always exemptions to that, but it offers asset protection, and that's why you do an irrevocable trust. But in return for that protection, you lose control. So if I had an irrevocable trust, I could be the beneficiary, but not the trustee. Where in a living trust, I'm using the assets and I'm the trustee at the same time. So you give up control automatically when you transfer it into an irrevocable trust. Number two is once the asset's in an irrevocable trust, it can't be transferred out. It has to stay in that trust. It can be sold once you die, but it has to stay there. So I'm very peculiar before I add that in. Now, trusts are like bank accounts. You can have a savings account, a money market, a checking account. The trust that we do is like your everyday checking. An irrevocable trust is kind of like a money market account. Like it has restrictions, right? Can only take so many deposits, can only make so many distributions per month. There's restrictions to it. The restrictions with this is you don't control. If you want to sell an asset in an irrevocable trust or transfer ownership, you have to have the trustee sign off on it. And it can't be transferred out of an irrevocable trust. It can go for one irrevocable trust to another irrevocable trust, but it can never change characteristics or there could be consequences. You lose the asset protection, which is the main consequence. So we don't want to do that because that's the whole reason you're doing it in the first place. So irrevocable trust, think of it like building blocks with trusts and estate planning. There can be different things. You might want a gun trust or an irrevocable trust, but we'll have a conversation. I would say a vast majority of my clients don't utilize those, but if it's good for you and you really have an asset that you're worried about, you got a $2 million home and you live in a state with a $20,000 homestead exemption, might want to look at an asset protection trust. So, but that's a conversation we have. That's why we listen and consult.
Love it.
Great
Awesome.
questions.
I think we got all the answers so far. And obviously, you guys, if you have more, just scan the QR code or click on the link that I put in the chat box. And truly, you can easily just get a free call. I've had great experiences with people who have had the free calls. They've been really appreciative of it. They've learned a lot. And there's been a number of people who have signed up for some services. So, you know, this is one thing that I like to do when we bring these sorts of speakers in is remember, you know, this information is really important for people that you have in your sphere of influence. How many people are investors, own multiple properties, own businesses, are just human beings that have families that don't have this stuff set up? We don't always need to be the resource for real estate. We just need to be the resource so people have a better quality of life, a better business, a better future. Because when we're the connector and we're the go-to for all things, we always get their real estate business. And if you don't know what to go talk to your sphere of influence, your past clients, your friends, and your family about right now, I think this is a very good thing to go talk to them about. And this is going to be out on my YouTube channel, so you can watch it again. You could share it with people. You could let them know that because of your relationship within our group here in EXP, you have an opportunity to provide a free call to them, and just help them make good decisions about their business and life and continue to develop that relationship. So always take what you learn here and bring it to somebody else, pay it forward. And that's how you're going to get a return on your investment of this time in your business. I'm very hopeful that that will become your reality if you do that. So Greg, thank you so much for your time as always. Really, really appreciate you. You guys remember this is live streamed forever in EXP Family Tree. So if you want to watch it there, you can do that, tag your friends there, or go ahead and check out my YouTube channel. It'll be up within the next 24 hours. Thanks you guys for joining us. Appreciate you all. Have a good day.